David Rivkin, his partner at Baker Hostetler, served in the Justice Department under Presidents Reagan and Bush and is a close friend and advisor to this show, Thank you, David, for joining us.
Good to be with you.
We've been talking backwards here, doing it backwards to the implications, what citizens should do or concerned about these decisions. Haven't really focused on the decisions themselves. Can you walk us through quickly the two decisions, what was said, and whether you think these opinions, majority opinions, were justifiable?
They're not. These are not great decisions. They could have been worse. That's about the only redeeming aspect. As far as Hollingsworth, which is the Proposition 8 decision dealing with a California referendum that barred same-sex marriage, the court punted 5-4. Actually, mixture of both liberal and conservative justices on both sides, saying that because the government of California stopped defending the initiative in the middle of a district court challenge, the private citizens who stepped in under California law to defend it did not have Article 3 standing, could not do it in federal court. In the Windsor case, which was a challenge to the Defense of Marriage Act, specifically to Section 3 of the Defense of Marriage Act, which basically for federal purposes of approximately 1,000 federal statutes, refused to grant recognition to same-sex couples, even if the state in which they lived in accorded recognition to a union as a marriage. That section went down as violative of both federalism and equal protection clause, 5-4, with Kennedy providing the decisive vote.
If, on that last one, so if I live in the state of Washington, which has same-sex marriage, I now can get the federal benefits, correct?
Tax benefits and other benefits, that's correct.
If I move to Texas, can I?
Very unclear, and this is one of the difficulties with that decision. That's why it's wrong, because the federal government does have, if nothing else, a compelling interest for ease of administration, figuring out, Bill, what would happen. You're absolutely right. And let's say you're in the military, you moved to Texas against your will. On what basis are you going to determine whether somebody is married? On the basis of the decision by one state several years ago, which you no longer reside, or on the basis of the law of a state in which you now reside? And let me say this, the decision, at least in the first 9 pages, is replete with pines to federalism, how determination of what is a marriage and what is not a marriage is to be done at the state level. If you were married in the state of Washington and then, let's say, abandon all ties to it, you move to the state of Texas, you're now paying Texas state taxes, get benefits from the state of Texas. On what basis would the federal government continue to accord recognition to your state of Washington marriage?
Okay.
It would be an insult to the state of Texas, which does not recognize your marriage. Very, very unclear how. Now, by the way, the proponents of a same-sex marriage are going to push this administration. They said so even before the decision, that if any state, Bill, any state recognize your marriage, then you get all the federal benefits. In that case, what you would have is, to coin the term, marriage tourism. Every same-sex couple in the United States would get married in a state that allows that, Las Vegas-like, and then it doesn't matter where they live.
Got it. Before the phones start ringing from Texas, I know our brilliant friend David Rivkin didn't mean to say paying state taxes in Texas.
Forgive me, I do not live there, but yes, it's a great state in that respect.
All right. We got the great Rivkin finally. Okay, good.
Let's say Louisiana, Bill.
All right, very good, very good. The heart of this thing, it seems to me, is Kennedy's decision in Windsor. We have a caller who wants to ask about that. I'll get to Pat in a second. Let me just say to the other callers, we want to focus on the decision, have questions or comments about the religious aspects, implications, other things. If you can save them for the next hour, I'd like to make room for people who want to talk about the decision. Let's go to Pat in Delaware and let Pat set it up, and then I'll add to Pat's question for David. Go ahead, Pat.
Good morning to you both. I wanted to express concern over the religious liberty implications, because with the whole language of discriminatory animus, it seems as if that it's a further vehicle for governments to continue to shut down religious organizations like they've done in Massachusetts with the adoption agencies. And I wonder, frankly, if Catholic schools are at risk because they would be teaching discrimination. So I was just wondering if you could comment on that.
Let's back up, David. What was the heart of Kennedy's opinion in terms of what it augurs for the future, portends for the future?
It's confusing. I frankly expected a pure federalism opinion, which basically, in the first 9 pages, as Scalia points out, is the center of that, which is, look, marriage is so much driven by state law. This is a big bite. This is a federal government putting its thumb on the scale with regard to 1,000 statutes. It goes down. And it would have been not right, but in my view, palatable, especially since Kennedy venerates federalism more than any other justice in the court. Unfortunately, what your caller is talking about is things switched up to page 9, and then one can even argue that the federalism discussion is really not binding aspect of an opinion. The whole discussion about animus, bigotry, the fact that the federal government discriminated against a similarly situated couple because if you're married in New York, if you're a same-sex couple, your marriage would not be recognized for federal law purposes, but if you're a heterosexual couple, it will be lots of discussions. Frankly, it reads as if it was not really written by Kennedy, even if it's his opinion. So that is the most troubling aspect of the majority opinion. To briefly answer your caller's question, I don't see how that is going to impact much the private policies alleged to be driven by animals because, frankly, Bill, there are lots of other cases that deal with this issue and to what extent that kind of behavior, even by private institutions, can be impacted on how you balance with religious liberty. So I don't see that. Now, the good news, and I want to say it very early in the program, the good news is, I think, very briefly, there are 2 dissents. One by Scalia, which, brilliant as it is, basically expresses desperation and says that it's all over for the fate of marriage at the state level. No state in the very near future would be allowed to deny same-sex marriage privileges. And then Roberts, which reads it narrowly, says, no, it's only about the statute. It only talks about, it's a combination of federalism and equal protection. The question of whether or not states can deny same-sex marriage benefits is still open. I am frankly with Roberts. I think that Kennedy is very torn. I think in the future, when it comes back to the court, and will come soon enough, in the context of a state law, like Prop 8, for example, but with parties having standing, I think even now, I don't think any one of the 9 justices, including Kennedy, knows for sure how Kennedy is going to vote. My hope is he'll vote the right way because there will be no federalism considerations, all the rousing rhetoric about how it's up to the states. So I don't think that chapter has been written yet. So I'm with Roberts and not with Scalia, with all due respect to him.
All right. Well, with all due respect to you, our respect for you, why do you think, this is going to sound unpleasant, but I don't mean it this way, why do you think you know Kennedy's mind in the future better than Scalia does?
I didn't say it for sure.
Okay.
So I'm expressing a view, but let me answer this question and not toot my own horn. But
no, toot your own horn. I want you to be right. I want Scalia to be wrong. Believe me, I'm on your side.
Back in Obamacare days, lots and lots of people were predicting that Kennedy will not rule against the individual mandate. I was one of a very few who did. The reason for it is very simply, Kennedy cares about individual rights very much, but he's not unique in that respect. So are a number of other justices in this court and predecessors. But the essence of Kennedy's lifetime work is federalism. And then the issue is presented in a way that he has to choose between trampling federalism and, in effect, federalizing marriage and doing what a lot of people would urge him to do to protect individual rights. I think the federalism would win out. That is his most distinctive and I don't want to say it's not vanity, it's a wrong term, but it's a pride of authorship, pride for his entire contribution to the legal profession. I think in the end of the day, he would choose federalism, provided, Bill, a couple of things. First of all, it has to be a right state statute with no evidence of animus, written in very careful terms with no legislative history that includes some rants and raves against same-sex marriage, and it has to be well-briefed and well-pled. So if you present the right state court challenge, state statute challenge to Kennedy, I think you'll go the right way. I think Roberts believes in that. I think Scalia does not. But as I said, nobody knows. This is one of those instances where if you had on your show the 9 justices, and they're all telling you off the record what they think, not a single one of them would be able to say for sure Kennedy himself included, how he would vote.
Okay. That's a great answer. Actually, I've asked you, why do you think you know the mind of Kennedy better than Scalia? And you said, I know it at least as well as Kennedy does, his own mind.
I hope so.
Okay. But let me come back, because you're suggesting a certain philosophical consistency, and if he stays with a certain philosophical consistency, which we've seen the record of over his career, then he may decide.
On this one, Bill, a lot of people portray Kennedy as sort of a balancer, swing justice, going back and forth. But on federalism, if you look across the entire sweep of his career, going to his decision in Obamacare, opposition in Obamacare, going to Morrison, going to the entire sweep of cases implicating federalism, Bond. He's been consistent throughout. And very briefly, what's very important is Kennedy correctly believes that federalism doesn't just inure for the benefits of the states, that federalism, dividing power vertically between two co-equal sovereigns, is the strongest guarantee of individual liberty. So there's a consistency in terms of reconciling his commitment to federalism and his commitment to individual liberty.
Do you think honors, awards, medals, commencement addresses, and celebrations and covers of national magazines can affect the judge's judgment? Because that's what he's about to get, a lot of it.
Yes, they were all human.
Yep.
It does. Some, and I would say this, there's some, to varying degrees. I would say somebody like Thomas is zero.
Yeah, zero. He doesn't read the papers.
Right. Scalia, and, his view of being in the Supreme Court is a kind of a monastic vacation. He should be totally insulated from political pressures, not only by life tenure, but conspicuous disregard for the mores of public opinion.
He told me at a cocktail party, he said it's like going into one of those huge bank vaults, he said, and closing it behind you. And he said, and that's what it should be.
Right. Scalia, not so much.
Okay.
I have to say a number of liberal justices, not so much either. I think Ginsburg, again, I don't want to be going for all nine, but to varying degrees. Look, I think how it's going to be sliced is going to matter to Kennedy, is going to matter to the chief, but we'll see.
We'll see. You can stay in one more segment?
Of course.
Thank you. We'll have more questions for David Rivkin. Yeah, I can see the honorary degrees starting to pour in, commencement addresses, awards. He'll be asked to be the chief judge in the trial of Hamlet at Harvard Law School. We'll be back. David, recently having a conversation, and someone said, look, if we lose one member of the conservative side, it's all over because then you will have, five liberals and just forget it. Is it fair to say, as I've heard some people say, that our side, if you will, the conservative side, I'll say my side, generally Roberts with some exceptions, Roberts, Alito, Thomas, Scalia, try to be good, thoughtful, honest brokers of the Constitution, and the others are ideologues, or there are ideologues on the left and ideologues on the right? How do you answer that?
Well, I'd like to think, Bill, that nobody's a pure ideologue, but let's just say that the four justices you mentioned, plus Kennedy, I think agonize a great deal more in dealing with difficult issues and try to reconcile their principal convictions with the strong tug of their policy preferences. I think that the other four justices do not wage an internal struggle. Therefore, they're eminently predictable on difficult issues. So I wouldn't use the word ideologue, but yes, I can give you 100% certitude if we have one more liberal justice, how they would vote in a whole range of issues, including this one. It would be all over for traditional marriage at the state level. They would not be troubled by it. It would not, if you think about it as the jury, they're not going to deliberate for a week. It's going to take them very little time to come out. So if we lose a conservative or middle-of-the-road justice like Kennedy, this issue and many other issues are done for.
If you have people like Elena Kagan or Breyer taught at Harvard Law School when I was there, these are not dumb people. These are not pure ideologues. These are highly trained, highly intelligent people, correct?
They are, but let me say this. They start with a very different constitutional narrative, and I would direct listeners to the Scalia's book about sort of constitutional interpretation, but interpretation of legal text in general. In their view, Constitution is infinitely malleable. It can mean a variety of things. There's no discernible sort of fixed meaning to any of the constitutional provisions. And if that's true, Bill, then it's easy. Then you rule from your gut. If you basically say what makes sense policy-wise, and then you presto pronto just plug in an interpretation of malleable constitutional terms. So you have no angst, you have no difficulties. Everything is easy.
Gotcha. Derek is in Spartanburg, South Carolina, on our superstation. Derek, go ahead. You're on with David Rivkin.
Yes, how you doing there, Bill?
Good.
I'm a little disappointed, but I'm not surprised about the decision dealing with the Proposition 8 and DOMA. But my issue was that I think it's going to go back to the Supreme Court in a couple of years because they're kind of punting around the question of making same-sex marriage legal for the whole country. But I believe it's going to be back in the Supreme Court within 2 years. So it's just time for all Christians to unite and politicians to stand up and fight this thing, because it's not just about marriage. It's about, if they take away marriage, it's mother and father and brother and sister and uncle and aunt.
Okay. Thanks, Derek. We have a bad connection.
No, I got that, Bill. Very briefly, I respect the caller's passion. I share it, but let me urge everybody. It's very important to conduct this debate respectfully. The more we can give light to the argument that supporters of traditional marriage are, espousing animus and hatred, and I'm not saying we can never take it off the table because the other side would continue to espouse it, but the better off we're all going to be. So to the extent that we care about this issue, we have to debate this respectfully.
Yeah, it makes it much easier for the other side
to demonize us.
It can characterize us as haters, and if we give them some evidence or suggestion that there may be truth to that. Could you say it just a word, because it was so excellent on the break, because I wasn't aware of this, and I don't think the audience is. One hope for Kennedy here is his rich history here in terms of being a disciple of federalism. You said a little about it on air, but
right.
You elaborated on it.
Well, this is one aspect of Kennedy's jurisprudence has been his lodestar, and it's very important because it's reconcilable with his commitment to individual liberty. Kennedy, quite correctly, framers believed in that. That's the diffusion of power, both horizontally among the three branches of federal government, particularly vertically between the states and the federal government, is the best way to protect individual liberty. Kennedy wrote about it with great passion, most in addition to the Obamacare case about a year early in a case called Bond. So this is my again, expectation is if a decision comes where he has to choose between his commitment to federalism and his commitment to individual liberty, he will say federalism because it advances individual liberty. And on this issue, he has been 100% consistent throughout his entire career, which is quite rare.
So a well-framed appeal, thoughtful, articulate, bearing no negative animus, etc.
With a right state statute, I frankly don't know which one. And this is the problem with litigation, Bill. You're always on the defending side. It's the other side is going to look at the most vulnerable state statute and drive it hard.
Got it. David Rivkin, thanks very much. Appreciate it. Thank you.